So it is with great pleasure that I'm introducing the TaxCOOP 2017 debate. This year's debate is about tax transparency. Over the past 15 years or so, numerous developments have put tax transparency on the policy agenda in many countries. Activists, international organizations, governments, and organizations such as accounting standard boards have been addressing tax transparency issues, and norms have emerged, for example, in the extractive industry, or more recently for large multinationals. Issues regarding the objectives, the advantages, and the consequences of more tax transparency continue to be raised from the perspective of governments, tax authorities, taxpayers, professionals, and civil society. This debate will highlight some of the costs and benefits of tax transparency. We are grateful to two renowned experts who have accepted to go along with this debate on tax transparency. Presenting the argument in favor of tax transparency, Michael Lennard. Michael Lennard is chief of the International Tax Cooperation Section in the Financing for Development Office of the UN. His work focuses on ensuring the fairness and workability of international tax norms and encouraging cooperation to improve tax systems. Presenting the argument against tax transparency, Dominic Belley is a lawyer, tax litigator, a partner, and the leader of the TaxCOOP in Canada at Norton Rose Fulbright. He has appeared as lead counsel in civil, criminal, or constitutional matters in more than 100 cases. He has argued 4 cases before the Supreme Court of Canada between 2012 and 2017. We are also delighted to have a panel of 3 judges who will moderate the debate and share their thoughts on the arguments submitted before concluding. The first judge, Louise Otis, works as a civil and commercial mediator and arbitrator at the Canadian and international levels. She is also adjunct professor at McGill University's Faculty of Law. She is president of the Administrative Tribunal of the OECD. Second judge, Manuel Montes, senior advisor on finance and development at the South Center in Geneva, was previously chief of development strategies, United Nations Department of Economic and Social Affairs. The third judge, J. Rosengard, is a lecturer in public policy at the Harvard Kennedy School. He has 40 years of international experience designing, implementing, evaluating development policies in public finance and fiscal strategies, tax and budget reforms, municipal finance and management, intergovernmental fiscal relations, and much more. So before I turn it over to the judges to explain to you how the debate will proceed, I would like to say first that translation might stop at one point during the debate. So the debate will be held in English, and the translation in French, unfortunately, would stop at one point at around 12:30. So I now turn it over to Judge Otis for the explanation of the debate. Thank you.
Thank you, Lynn. First, the role of the moderators or the judge. The moderators will preside over the debate. Our role is to maintain order and enforce the rules. Except in the last round, we shall not take an active part in the debate unless it's necessary to protect the rights of a participant or for reasons of procedure. In the final round, the moderators will have the opportunity to ask one or more questions to the debaters. The debaters will have the right to determine whether and how to address the moderator's question within their allotted time. Decisions of the judges are final. Therefore, debaters shall accept such rulings without questions. As you probably know, we judges like very much our decision being final and binding. The moderators shall be assisted by a timekeeper. Now I'm turning over Jay Rosengard to explain the rounds of the debate. Jay?
Thank you. just a note before the explanation, I just want to say it's an honor and a pleasure to participate in the third TaxCOOP debate with my dear friend and colleague, Judge Louise Otis, who is the only real judge among the three of us. So there will be 5 rounds, and the first 4 rounds of the debate will be dedicated to 4 separate resolutions. At the beginning of each round, moderators shall read out the resolution. And then for the first 4 rounds, the affirmative side will present arguments in support of the resolution for about 6 minutes. The opposing side will respond to the affirmative side's arguments for 4 minutes, and vice versa. And then the 5th round will consist of closing arguments. The moderators may ask 1 or more questions to push our debaters or clarify previous remarks. The opposing side will present further arguments against the 4 resolutions, answer questions that may have been raised by the affirmative speaker or the moderators, and present a closing statement for about 3 minutes. And finally, the affirmative side will present further arguments in support of the 4 resolutions, answer questions that may have been raised by the opposition speaker or the moderators, and then present closing statements. And then Manuel, our third judge, will explain how the conclusions shall work.
Thank you. Lively and constructive debate is the goal of this session. Debaters shall remain respectful at all times. Ad hominem arguments will not be tolerated. The moderators have the power to intervene. The outcome of the debate shall be an informative one. The audience may be polled for an aggregate vote on the outcome together with the moderators. This is not a competitive debate, but a frank and candid discussion is encouraged. Moderators will conclude the debate with a few brief remarks, followed by their decision on the merits, and the audience will be polled for a popular vote. So now I turn it over to Louise for the first topic.
First question, we call it resolution number 1. First, be it resolved that tax transparency requirements are essential to increase governmental capabilities to control compliance and to enhance their understanding of businesses, particularly multinational. Mr. Lennard, the floor is yours for 6 minutes.
Thank you. My affirmation of this resolution stems firstly from the fact that there are severe information gaps between what taxpayers know about the conduct of their business, especially multinational enterprises, and what tax authorities know. I think we have to begin by recognising that there is a severe gap between that knowledge, and the complexity of global value chains only exacerbate this. And the other factor is that more and more developing countries are being involved in those global value chains. So they have to learn, and they can only learn in a more transparent environment about how business is done and what tax decisions are taken. Transparency requirements, including the tax policies of companies, the tax structures that they adopt, and the taxes they pay, help ensure that tax is paid as legally due, and that limited government resources are targeted where the risks are, at the multinationals which are seeking to avoid their tax obligations, or the taxpayers may not be multinationals. Thirdly, transparency does help measure the contribution that a company is paying to society. And I think this measuring aspect is important, and there needs to be transparency for that to be effective. It helps, as I've mentioned, differentiate the risk profile of industries and individual taxpayers, and that's important for taxpayers. As a benefit for taxpayers, it means all taxpayers needn't be treated the same. They needn't all be treated with suspicion. Confidence can be built in the system, and audits and so forth can be targeted at what I've called the most deserving recipients. Voluntary transparency doesn't meet the test of fairness and equality amongst taxpayers and citizens more generally. And I think it's really important to remember that we're not just talking about governments and taxpayers, we're talking about the wider citizenry who have an interest in tax systems and in the development that it's important towards. Taxpayers receive the benefits of a civilised society. They receive the benefits of education systems, health systems, infrastructure, and transparency, backed up by legal enforcement of law, which is important, prevents free riders being disadvantaged. There's some suggestion that we shouldn't look at subjective motivations, but I disagree with that, because I think a demonstrated subjective motivation to game the system is a fairly reliable pointer to objectively gaming the system. And when subjected to, for example, a reasonable person test, how would a reasonable person look at this arrangement, it can point to these outriders and the free riders that I've talked about. Finally, international trade and business requires some sort of stable and predictable relationship internationally, as well as domestically. Transparency is an increasingly important part of the bargain struck to achieve this. We can't have the certainty that business seeks without transparency about what is going on in the business world. Thank you.
Good morning, everyone, and thanks for having me. I have the task of arguing against virtue this morning. This is not a simple task. I'm not against tax transparency. That's obvious. What I'm against is that the proverbial tax robot that Professor Burson talked about a few minutes ago, that the tax authorities be eventually connected like a tax robot to the books and records of the taxpayers, and that eventually, anytime there's a discussion about a potential tax plan, anytime there's an advice that is being given to a taxpayer, albeit on a perfectly legitimate tax plan or tax reorganization, that this information be automatically communicated to the tax authorities. Transparency at the tax level entails access to objective facts only. And by objective facts, I mean contracts, resolutions, financial statements, the kind of documents, the kind of information based on which income is computed and tax payable is determined. Subjective information, the reasons why a taxpayer has decided to enter into a contract, unless specifically provided by law, should never be communicated to the tax authorities. Furthermore, the information that has to be communicated to the tax authorities, objective information, has to be clearly identified in the tax statutes domestically. At this point, there's no supranational parliament. There's no supranational tax authorities. Taxes are levied by government at the local level, and tax conventions are not intended to levy taxes. They are intended to avoid double taxation. They're intended to make sure that the flow of capital from nation to nation is as efficient as possible. In a typical constitutional monarchy like Canada, the UK, Australia, the survival of government is at stake whenever a new tax statute is about to be enacted. That wouldn't be the case should taxes be levied at the international level, and somehow the power to tax could be transferred to supranational authorities, and the people would have absolutely no control on the way in which taxes are levied, on the way in which businesses are regulated. Therefore, tax transparency, so long as it targets objective information intended to compute income taxes at the domestic level provided for by a statute, in a competent jurisdiction, I have absolutely no objection. As for the knowledge gap, can be simply dealt with through a question of burden of proof. It's obvious that whenever a tax authority decides to tax a taxpayer, taxpayers in a privileged position, it's his business, it's his organization, it's his tax plan, it's his employees, it's his plant. However, the burden of proof that the tax authorities have to meet is not beyond reasonable doubt. In most jurisdictions, the tax authorities can even issue a reassessment based on assumptions, and it's up to the taxpayer to prove that the reassessment is incorrect in fact and in law, so the knowledge gap can never be invoked in favor of tax transparency. Thank you.
Resolution number 2. Be resolved that A, the benefits of tax transparency towards tax authorities justify the increased cost of compliance and risks for taxpayers, and B, lack of sufficient transparency from governments does not justify lack of sufficient transparency by taxpayers. We're going to reverse the order now and begin with the opposition.
Not that I am against protocol, but I'll start with the second proposition. B, lack of sufficient transparency from governments does not justify lack of sufficient transparency from taxpayers. I disagree unreservedly. Tax transparency is a two-way street. If governments at the local level and international organization at the international level how to require tax transparency frequently on a daily basis from taxpayers, well, they have to take into account that the same will be requested from the taxpayers. What does that mean? It means that tax authorities must disclose their goals, audit or investigations, for instance. There's a clear demarcation between an audit and an investigation. The end result of an audit is the taxpayers' dollars. The end result of an investigation, it's the taxpayers' liberty. Well, in most jurisdictions, the Minister of National Revenue will have two sets of powers, but the fundamental information remains the same. Financial statements, resolution, contracts, and whether or not the minister will use those documents to further a perfectly legitimate audit to issue an assessment, or to try to charge the taxpayer, put him in jail, while those goals have to be disclosed. Tax transparency calls to that. The goals in terms of the audit, is it domestic or international? Is it based on domestic law or a treaty? Is it corporate or personal? Is it income or capital? Whether the taxpayer that is targeted by the audit is really the taxpayer that the tax authorities intend to issue an assessment again. Or are we requesting information from a taxpayer with the intention of issuing a reassessment against a third party? Because there might well be conflicting interest between the tax authorities and the taxpayer. And we have to take into account a different group of interest from the third parties, where the third parties may not be represented in the relationship between the tax authority and the taxpayer. There is absolutely no way for the taxpayer to clearly understand the interests that are at stake and to protect those interests if the original goal of the tax authorities are not fully disclosed. Perfectly appreciate, not to say that I'm anticipating my friend's argument, to the effect that transparency, as far as governments are concerned, should not go as far as to disclose what we would call sensitive information. You know, the relationships at the state level should never be impacted by disclosure information to taxpayers at the local level. I disagree. I disagree. If the goals of tax authorities internationally is to go after multinationals, and if going through each and every step of the international tax audit, the taxpayer realizes that a piece of information does not come from Canada, my home country, but has been disclosed by another country, the United States, the United Kingdom, France, countries with which we Canadians have international tax conventions. The taxpayer should be entitled to the same level of disclosure in terms of information he would get from Canada, as well as a friendly country like the United States, France, or the United Kingdom. If the information based on which a taxpayer has to face his local tax authorities is from another country, that other country should disclose its own goals to the Canadian taxpayers and vice versa. Finally, at the very end of the audit process, should, unfortunately, a reassessment be issued, the basis of the assessment has to be fully disclosed. As I mentioned a few minutes ago, tax authorities are fully entitled to base their assessment on assumptions. In other words, they don't have to have a complete picture of the taxpayers' businesses in order to issue a reassessment. However, should the assessment be based on assumptions and not facts, those assumptions have to be demolished by the taxpayer. The taxpayer has to know everything, be it based on domestic information or international information.
Thank you. The transparency by tax authorities as to their requirements, their priorities, their areas of focus is very important and to be strongly encouraged. We encourage it in the UN. And in fact, transparencies by taxpayers will actually help hone those priorities and areas of focus, which will benefit taxpayers. So it's not just about costs and risks to taxpayers. There are benefits to transparency systemically. It's hard to require countries to a particular standard of transparency or a deep standard of transparency, because there are risks that in some respects you'll be imposing Western views on countries with different traditions. But there are areas where encouragement of government is important. I recognise that, and that's not contrary to the submission. Transparency is never total in any case. It's like an X-ray. You don't see everything. You see what's necessary to check the health of the system. But it doesn't, and the domestic law exceptions to that will vary, but it doesn't mean that they can or should be imposed on other countries. Ability to harm foreign relationships is a still widely accepted reason for non-disclosure by governments. You can question that, and certainly in the UN we believe it's open for all these exceptions to be looked at, whether they benefit the taxpayer or whether they benefit the government. And transparency is indeed a two-way street, but it's not dependent on the other side meeting its obligations. If you have a child in the back seat hitting his brother, you don't say that the answer is that the brother hits back. Generally, you'll say, let's deal with the cause of the problem and stop the first chap hitting. So those are my essential requirements, that there is a justification of the complexity and cost. And over time, that will be decreased. And I think there will also be an encouragement of voluntary transparency. A lot of the concern about transparency is really, I think, about global formulary apportionment, which is not really in practice an issue. Thank you.
Resolution number 3. Third, be it resolved that tax transparency could provide useful information to the public in order to hold corporations socially responsible with regard to their tax obligations. I call on who's talking first? With Michael. Please, Michael.
The affirmative side.
Make sure I'm on the right one. The wider citizenry paying pay-as-you-earn tax and VAT and other taxes, and with less opportunity for minimisation than multinationals, has a legitimate interest in the way tax systems operate. And shareholders and consumers also have an equally legitimate interest in knowing what they are supporting or buying into, as I'll mention later. And there is a social contract. The elements of that are not always clear, but it's like right and wrong. There will be differences between people about what's right and what's wrong, but there are some common elements and there is a real difference. And the social contract is not just with governments, it is with the wider society. So even if the government is not acting as it should, which we should try to improve, there is still this contract with the wider society. And that contract is, in the words of the Common Vision Project, the Responsible Tax Project, is to ensure that communities within which we all work are stable, well-funded and operating well. So there is some commitment, which is greased by the fact that you do benefit from the results of taxes in a country, to recognise that there is a wider relevance to be considered than even just your immediate shareholders' interests. And by the way, your shareholders have an interest in you being recognised as a responsible company and a long-term partner for a developing country. Legal issues are not enough because, as the Responsible Tax Project has said, rules on their own aren't enough, where there is room for subjective decisions about how businesses are structured and how they operate. These decisions can be exercised with a view to a common good and a social contract or not. And I think it's quite legitimate to say it's not just about the law, it is about how those decisions are exercised. NGOs do have to be held to account, like anyone, and they should be transparent too. And I'm sure business will keep them to account as to what they say. And business will be increasingly able to do that. Now, business should be equally prepared to defend its practices as economic partners for states and their citizens. The obligations to pay in accordance with law increasingly recognise the importance of substance over form and assessing that and the objectively ascertained purposes of actions as being relevant. Just finally, modern goods and services are touted as buying into a lifestyle. And as Chuck D has said from Public Enemy, before people buy from you, they have to buy into you. So it's not just about laws, it's also about reputation. It's also about how the public, what expectations it has of you as a partner. And transparency is an essential step to corporate accountability in the future. Thank you.
You may or may not have realized that preparing this debate was actually kind of fun. There is no social obligation to pay taxes. And I think the greatest judge never to sit on the U.S. Supreme Court, Justice Lennard, said there's no patriotic duty to pay taxes. There may or may not be a legal obligation to declare income. There may or may not be a legal obligation to compute and pay taxes. There may or may not be a legal obligation to disclose the basis on which income and taxes are computed. But as far as a social obligation or a patriotic duty to pay taxes, that simply doesn't exist. Taxpayers simply has to ask one question: what am I required to pay pursuant to a domestic statute? That's what it is. However, this proposition does not mean that a taxpayer or a company has no social responsibility whatsoever. And if we take the example of a corporate multinational, the corporation's duty will be vis-à-vis its shareholders, its employees, its clients, its suppliers, former employees who would get pension, the environment, of course, governments. But governments is only one stakeholder. Government's interest and government interest in maximizing its tax revenues is one element that has to be integrated into a much more complex formula. Social responsibility might entail or trigger the will of a company to contribute a little bit more to the services that have to be paid for by the government. But at the same time, the corporation has to realize that tax minimization is also part of good governance. It is part of good governance, not for the sake of minimizing taxes at the beginning of the road, but what is the impact of tax minimization at the end of the road? And by the end of the road, I mean that tax minimization at the beginning will mean maximization of shareholders' value at the end. And maximization of shareholders' value is, of course, to the benefit of the company, but first and foremost, to the benefit of society as a whole. Ask yourself, who are the most significant institutional investors of the largest public companies on the planet? Pension plans. Pension plans who care for people who used to be clients, suppliers, shareholders, employees of companies. So tax minimization in and of itself will not solve pension problems at the very end of the road, but it is part of the solution. And that's why it is perfectly legitimate first for a company to ask the question, what are the legitimate tax minimization strategies that could be implemented? And secondly, to integrate those strategies to the global context of their duties vis-à-vis shareholders, clients, employees, and the governments. Thank you.
Yes, I think just to add to your last comment, I think that very soon we should probably seriously consider that in a short while we will have a robot pension plan. So you will have to work on it. Resolution number 4, fourth, be it resolved that access to information by tax authorities does not hinder the protection of confidential information, nor does it undercut the work of professionals, I mean accountants or lawyers, for example. And we began with the opposing side.
My best friend. I'll start to say that tax laws are not complete codes, and by complete codes, I mean that you cannot have a tax statute that works on a standalone basis. Tax statutes will not reinvent contract laws. Tax statutes will not reinvent corporate laws. Tax statutes will not reinvent insolvency laws or criminal laws. Tax statutes have to work, be construed and be applied consistently with other statutes. That's another way of saying that the other statutes could work perfectly well without taxes, but taxes cannot exist without the other statutes. Among those group of other statutes, we have laws and regulations that provide for professional corporations, two of which are similar importance to the tax profession, the accounting profession and the legal profession. Currently, at least in Canada, in the United States, the United Kingdom, there's an obligation that is semi-constitutional, quasi-constitutional, which is the solicitor's client's privilege. In other words, when a taxpayer goes to a lawyer and requests a tax advice, the tax advice on a legitimate tax planning or tax organization or tax minimization strategy will have to remain confidential and is not subject to disclosure to the tax authorities. And most of the tax statutes have respected this fundamental principle, if only for practical reasons. Consider the alternative. You have a taxpayer who requests a tax advice. The legal advisor gives a full advice. Tax authorities goes to the legal advisor, requests full disclosure. The taxpayer has nobody to represent him. Goes to a second tax advisor, legal advisor, discloses everything. Tax authorities would go to the second tax advisor. There would be no end. So, solicitor's client privilege is the umbrella principle that should be respected at all costs. My proposal would be that the duty of confidentiality of CPAs, chartered professional accountants, chartered public accountants, the accounting profession in general, that their duty of confidentiality be somehow elevated to the same statute. First of all, because in practical terms, the legal practice and the accounting practice as far as tax is concerned is basically the same. There might be differences, but the core of both practices is the same. But more importantly, for the vast majority of taxpayers, they cannot see and appreciate the nuances between getting an advice from a tax accountant, getting the same advice from the tax lawyer. But these taxpayers deserve protection. And the most pressing, the most important protection that has to be secured, again, going back to financial market regulation, is the discussions that will take place each year, sometimes several times a year, when financial statements of public companies have to be prepared. Fundamentally important that the financial statements certified by the accounting profession be a fair, accurate, and reliable picture of the public company's financial situation. You have to project your results in the future. You have to present your current situation reliably. And one of the elements that will have to be taken into account is your tax risk. Whether or not you're subject to an audit this year, next year, 2 years. Whether or not the previous taxation year is subject to an audit. Whether or not it's statute barred or not. And these discussions have to take place on an ongoing basis, and the end result will be reflected and has to be reflected in the financial statements in terms of numbers. But that should be the end of the story as far as I'm concerned. The accounting analysis and the legal analysis behind the decision to take a reserve, for instance, so that the financial statements will be a fair reflection of the taxpayer financial position on a given date, this discussion and the subjective opinions that are shared between the taxpayer and his professional advisor should never be disclosed. Otherwise, it will induce less discussion, less disclosure, less reliable financial statements, and who are going to be the losers? Everyone. Thank you.
To go to the second prong of this resolution first, access to information does not hinder professionals in doing their work. In fact, looking after them, it should make the right sort of professionals sleep a bit easier at night. The reason I say that is because it's consistent with their ethical obligations to be open with the government, and it's consistent with taxpayer charters which business has been involved in negotiating the text of. Certainly a lot of good young employees would rather be operating as a professional where they can actually give out information about how business is done. Of course, there's limits to that, and a lot of those limits are at the domestic level. Mention was made of the accountancy advice, and of course in most countries that's not confidential. Whether it should be or shouldn't be is a decision for countries. But again, the approach of Western countries, itself inconsistent on this and other issues, can't be imposed on developing countries with different systems. There needs to be a dialogue and to try to secure as much agreement as possible about what should remain confidential and what shouldn't. And that result of that needs to be relevant to countries generally and to create ownership, to really create the certainty that business is always asking for. If there are international obligations, they must be met. Pacta sunt servanda, treaties are made to be kept. And also, customary international law reflected in the Vienna Convention of the Law of Treaties, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. So where there are treaty requirements as to information to be provided, they have to be met. And countries have to deal with the internal difficulty that they're in breach of international law until they remedy their domestic law. Unless we meet our international obligations, we will have chaos and we'll have unilateral action that, again, will not help taxpayers generally. And finally, as I've mentioned, professions themselves recognise that laws are not enough. They have ethical obligations. They don't just say follow the law and that's it. They do address the wider responsibilities of professionals and the reputation of the profession. And this is the same situation here, that the information exchange addresses the wider responsibilities of corporates and the reputations of corporates generally. And it's in the interests of those who are trying to meet their tax obligations to make sure that they're not treated with the suspicion that they will get if there's no real exchange of relevant information. And they will benefit, and it's important that they do benefit from the fact that the information supplied helps identify the ones which are trying to meet their obligations and those which are not. Thank you.
Now it's round 5, and at this point, each of us, your moderators, your judges, are going to ask you a question. I'll begin with the first one, and Michael and Dominic, you will answer. Is it essential that a severe domestic penalty regime accompany tax transparency measures to ensure their effectiveness? Michael.
Well, it will vary. You need to have some sort of severe penalties for the taxpayers who do not want to meet any of their obligations. But I think it has to be accompanied by guidance that helps companies which are trying to meet their obligations, and also it has to be accompanied by efforts to determine which is the sheep and which is the goats. But I think there does need to be some severe penalties, maybe in terms of onuses of proof, that if they can't displace an onus of proof, they get a pretty severe treatment. And developing countries are finding that an important way with limited administrative capacity of ensuring that tax obligations are met. Thank you.
There's a couple of angles through which I'd like to answer this question. First of all, the think I agree with the principle that severe penalties should be applicable, but there has to be an umbrella protection which is called the judicial system. So long as there's a clear path to get before a judge so that the penalty imposed by the tax authority can be revised by a neutral and independent arbitrator, I can live with such a system. So that's my first comment. Secondly, in Canada we do have a severe penalty system that applies to both the taxpayers for failure to comply with requests from the tax authorities, and secondly, basically the same regime applies independently to the tax advisors. And a huge debate was initiated a few years ago on the nature of the penalty regime. Is it a criminal or civil in nature? And the end result, based on the decision rendered by the Supreme Court of Canada, was that it was a civil administrative regime as opposed to a criminal regime. And I may be giving a surprising answer that I have no real preference between civil or criminal aspect of the regime, if only because the civil regime might look in surface less harsh and probably a little bit more easy to live with, but it affords less protection. In a civil regime, you cannot take the benefit, of not testifying against yourself. You have in a criminal regime, you don't have to. You're not compelled to cooperate with the tax authorities. Whereas in a civil regime, you may be called as a witness in your own trial, and whenever the tax authorities come to your office, you have a duty to support the tax authorities in their audit. So yes, I'm totally in favor of a fair, albeit severe, penalty system, so long as it is under the umbrella of an independent judiciary.
Jay? Thank you. Yes.
I also have one question for each debater. Some say that tax transparency is not an end in itself, but rather a means to an end, and that the ultimate objective is improved public accountability of the tax administration. So for Michael, from the affirmative side, are there types of tax transparency that do not lead to increased accountability that are in fact counterproductive? And then for Dominic from the opposition, are there alternative tools for increased accountability in cases where tax transparency might have unintended negative consequences?
Thank you. Just wait for the micro. Well, I guess there can be. If you, there are genuine situations where corporates have genuine reasons for not wanting to put out information. Information can damage them competitively, and there's sometimes a concern that information will be spread that will benefit local companies as opposed to the multinational, for example. So there would be instances where the wrong sort of transparency, not taking into account the realities of business, could lead to them saying, we will just close up shop. There's an issue at the moment amongst a lot of companies how much information they should provide under some of the master file, under the country-by-country reporting. I think they should take the benefit of telling the story, giving their company's story to the tax authorities, but some of them are concerned that too much information might lead to a lack of competitive position. There has to be a dialogue on some of those things. I think that it's pretty clear in the case of that there's not an issue. And in the past, for example, and this is my final response on this, kidnapping was used as the excuse to keep bank secrecy. And, there is a kidnapping issue if people it's known that they're rich. Often it's known because they drive around in Lamborghinis anyway. But there is an issue. But some of those reasons, which are valid in themselves, are overused and used in a way which is not to the benefit of the reality of some of these reasonings being given due consideration by governments. Thank you.
Judging by the tendency over the last 10 years, I think tax transparency is here to stay. However, two comments. First one, picking up on one of your last words, dialogue. I'm a firm believer in dialogue between taxpayers and the tax authorities. Not everything has to be controversial. Not everything has to end up before a court of law. Dialogue, negotiation, openness, simply be courageous enough to pick up the phone and propose alternative solution to a full disclosure of information, but getting to understand the tax authorities' point of view, getting to understand the tax authorities' goals, will lead to maybe a less invasive kind of tax transparency, but transparency in a more effective ways, so that the tax authorities can correctly allocate their human resources in terms of the audits that they have to carry out in any given year. And secondly, a more efficient allocation of financial resources at the taxpayers' level, because to be quite frank, these tax disputes can be quite expensive, to say the least. The other element I want to mention is that sometimes the system itself has the solution to its own problems. You want to foster tax transparency and tax compliance, offer tax incentives. If a taxpayer has an incentive in disclosing information because he will get a tax reduction, because he will get a tax credit, because he will get a recognition or a status within the tax apparatus, well, that's an incentive for the taxpayer to voluntarily provide information to the tax authorities so as to be in the system. He can be monitored, but he will be monitored willingly because there's something in it for him.
Thank you very much. Third question.
Thank you very much. I found this debate very helpful I learned something, especially from Dominic, about what has to be disclosed. And we can debate about whether the purposes of what the taxpayer did would or not be should be disclosed by law, right? And the question I have is the following: it's about imbalances. There are taxpayers' rights. We're talking about taxpayers' rights here, right? Is there a difference between? And this is a question to both Michael and yourself, right? The imbalances among taxpayers, imbalances between developing countries and developed countries. And basically, the first imbalance is among taxpayers, right? I mean, I cannot afford a very expensive accountant, right? To what extent are there imbalances between private privacy and corporation privacy? Is there an inbuilt social obligation on the part of the corporation, both private and public, because it is a state-created institution, right? Do you think? I mean, for both of you, right? This is the question. I mean, so is there an inbuilt additional obligation on the part of the corporation as opposed to the privacy of the individual, right? And the second question is between developing countries. Dominic said that there is no supranational authority, right? There's no supranational authority. How do we interpret? I mean, to what extent is it that the rights to privacy in any domestic situation could apply across the tax treaty, right? To what extent? I know this was a very important point that was made in this debate, right? So I wanted to ask both of you to answer both questions, right? So.
I'll just get the second question again, Butch.
So the second question is about imbalances between developing countries and developed countries, right? The question is to what extent are corporations required to disclose information that is required by the host country, right? Should they be protected by their own privacy laws, right, in where they're headquartered, right? Because there is no supranational law, there's no supranational authority. What do you think which principle should actually apply, right, in this kind of a situation? To what extent do we believe, I mean, the tax treaties that exist, and they are actually, a lot of them are contradictory between themselves on the tax treaties that any developing country would have signed on, right?
Just wait for the mic. Yeah. Well, on that, I think there is a difference. I think there is a recognition that if you're dealing with a developing country, not only is it not in a position to know as much as, say, the United States would know in its dealings, but it's also, there's a bit of self-interest in being open to them, because in the longer run, a lot of the best markets are the developing world, and there's a self-interest as well as, I think, a public interest in saying we should be open with these countries. Now, there is a responsibility on their side to actually listen to what you've got to say, not necessarily to agree. And I've always said it's important that they do listen, they do read the country-by-country reports and do respond to them and don't ask the same questions again. So there are responsibilities on both sides. But I think there is a responsibility to bear in mind you're dealing with a country which is new to transfer pricing, for example, and won't necessarily have the same knowledge. And if you take advantage of that ignorance, it may not be in the long-term interests of you or your shareholders, because you may not be seen as the sort of company they or others want to deal with much in future. The first question, whether there's a different standard for individuals and for corporations, I'm not so much sure there's a different standard. I mean, there's different risks involved in terms of individuals and corporates as to the provision of information and not. But I think the main thing is that corporates are in a much better position, not a perfect position, to actually provide the information and to provide it quickly. Sometimes, I have trouble with tax forms. They're quite difficult. But the resources available, I think, should mean that there are, more responsibilities and maybe different requirements in terms of what you want of multinationals, including understanding the business, how the business operates. And it's in the long-term interest for business that taxpayers, tax authorities do understand global value chains, do understand how all these intricate things are used, financing arrangements. It is in the long-term interest that they understand how business is done. Thank you.
Quite interesting questions, which, as far as I'm concerned, will lead me to talk about, one overreaching principle, which is the independence of the judiciary. As far as I'm concerned, the cardinal value to an efficient, reliable, and fair tax system. Is there a different level of protection for large multinational companies and private individuals? Legally speaking, the answer is no. Actually, there might be an increased level of protection for individuals, because normally tax legislation will protect the personal residence of an individual, where and the office of a company would not be protected the same way. There would be less protection afforded to an office as opposed to a personal residence. Practical terms, I have to say that sometimes the cost associated with a tax audit or a tax investigation can be so important that only large companies can afford to pay professionals, or I should say teams of professionals, to make sure that their rights are respected. But again, legally speaking, the protection remains the same whoever you are. And the good thing is that at least in major legal systems like Canada, the United States, I'm pretty sure United Kingdom and Australia, France, although I can only speak from the Canadian standpoint, even for a taxpayer, an individual that is self-represented, there's a path that is not expensive to have his or her day in court, present his or her case to an independent judge, be it the Tax Court of Canada or the Court of Quebec in provincial matters, and get an independent arbitrator to listen to opposing parties and render a decision, to use Madam Justice Otis' terms, that is legally binding. And sometimes, you know, even though there's clearly an imbalance between an individual that is self-represented and the tax authorities that has the governmental apparatus behind it, there's clearly an imbalance, but at least there's an impartial arbitrator that is there to make sure that this imbalance does not produce unjust or unreasonable results. And again, in terms of developing countries, I think that's the key to the development of a fair, mature, efficient tax system to make sure that whenever there's a dispute, the dispute is overviewed by independent arbitrators that large companies as well as private individuals can trust. Thank you.
So thank you very much, and I think that those last comments from our debater will be the final comments. Now I'm turning over Lynn Latulippe to explain the voting rules.
Thank you. So after hearing the arguments, you are invited to vote. If you are in favor or against tax transparency as it was presented by our excellent debaters for today's debate. We will let you, give you about 5 minutes to vote. You can go to the address that you have there on the TaxCOOP website. Under Debate 2017, you can vote. We will let the judges talk about this and decide, reach a decision, and we will get back in, let's say, about 4 minutes. So we give you a few minutes to vote, a few minutes to the judges to discuss, and we immediately come back to give you the result. I'm being told that there might be a problem with the website, so maybe too many people are watching live streaming and are trying to vote at the same time. So we will take a few minutes just to see if this can be solved, if everybody can manage to vote, and we will get back in 2 minutes. Okay. Everything you see, you should touch anything.
Yes, welcome back. So our unanimous decision will be rendered by Jay Rosengard. Jay?
So, much of this wonderful debate revolved around different definitions of the term transparency. And there were certainly legitimate reservations raised by the opposing side, and the call for dialogue between taxpayers and tax administrators is warranted. But we firmly believe that as it's carved in stone over the IRS headquarters in the United States, Internal Revenue Service, that taxes are the price we pay for civilized society, and that there is a moral obligation, moral responsibility beyond the legal obligation to pay taxes. We believe there is a universal social contract embedded in tax systems reliant on voluntary compliance for responsible tax transparency. So there is therefore a unanimous judge's ruling in favor of the affirmative side. But just to show that we were not biased by the public vote, the judges do not know the results, but Lynn will now reveal the results of the public voting.
Very small there and very close.
Oh, very
So
close. Yeah.
out of 67 votes, we have 52.6% in favor and 47.4 against. Thank you very much for this great debate. I think that the results show that it was indeed a very, very great debate. Oh, the mic? Okay. Is it working now? Oh, you did. Okay.
Can you hear me now? Okay, my profuse apologies, and for those who did hear, rerun. Okay, but the results will be the same. Much of the debate revolved around different definitions of the term transparency. And there are certainly...
No, you want to have the result there.
Oh, the results here.
Yeah,
Please, oh, here.
go on.
You should read it.
So the results, can you hear me now? Fine, yeah, okay. So it's in favor 52.6% and against 47.4% out of 67 voters.
And now it's time to conclude. So on behalf of my esteemed colleagues, I'd like to thank Michael, Lennard, and Dominic Belley for participating in this interesting, relevant debate, and we're very grateful for both of you. Thank you.
Can I just say a word? Finally, my thanks to the organization committee for this unique and tremendously interesting experience, both in terms of giving the speeches this morning in Geneva, but also preparing the presentation. I think it's the topic of the next decade, and having the opportunity to talk about it with you and through a live streaming, it's a tremendous opportunity. So thank you very much.
And I'll just add, I think I was lucky to get that side of the argument against such a great debater as Dominic. My wife will be happy. She was watching, or we're watching this. But thank you to everyone. I thought it raised some very important points, and the result itself doesn't actually matter. Thank you.
Thank you all very much, and we'll reconvene at 2:15.